Yes, thank you, Your Honor, for letting me respond to some of the points made by Mr. Barca, representing the Commissioner. Starting off with the authority of the court. This is a court of equity. The court has authority to solve all the problems brought to its attention, however they got here. They got here from a void case, and there are no facts that came out of that contested case in dispute. There's no facts now. It's purely a law case. And if the law is being ignored, if the actions of the Commissioner have no basis in law, as I'm alleging, then it is incumbent upon this court to declare what the law is. And the declaration of what the law is, as I proposed in my draft order, will set many, many things to right. Mr. Barca snidely comments that, well, he's asking for a class action lawsuit with things way beyond the scope of authority under UAPA. UAPA is the Uniform Administrative Procedures Act. It controls departments, servants of the governor. The department is a mere servant in agency working for the governor in service of the people. If a department is errant, operating outside of law, if the department is errant and operating outside of the statute, then the order from this court would force him back into the narrow channel from which he has leaped. He has leaped outside of his boundaries. Chancellor Gibson is very clear that Chancery has this plenary authority, and it is the duty of the petitioner to make sure that all harms that have accrued against him be addressed. Again, if these harms affect me, they affect every member of the public. There's 6 million registered motor vehicles in the state or more, and all those owners have the same rights I do. If the law is properly presented under the standards under UAPA, which is the constitutionality, compliance with the statute, is it ultra vires, is it arbitrary and capricious, and is the ruling based on all material facts? And that's the standard. The standard is not that somehow the limit of the review of the record constrains the court now in court. UAPA applies here, but that is an open gate at the beginning of UAPA that talks about contested cases and the standard for review. The standard for review opens up the entire matter laid forth now and laid forth in the record. The remedy of a non-compliant, errant commissioner will benefit all. And so the court is authorized, since it is in the judicial department, you are not an administrative officer, you are a judge who has this plenary authority in equity. You have that authority, as Chancellor Gibson explains in many cases about chancery authority, talk about this ability to bring all the harm to an end. The purpose of the Chancery Court, as it was in the 13th century, was to be the conscience of the king and to bring peace and harmony among warring parties and factions in the Great Isle. And the same is here, to bring peace between the state, which has abused us wickedly and immorally all these years. It is time for it to be brought to an end by a proper ruling. So no is my response there. There is not a limit on the remedies, simply saying I affirm or I deny Brad Buchanan's 62-page order and Christine Sapp's, the Deputy Commissioner's affirmation of that order after I protested and asked for reconsideration. You have much more than just to say yay or nay. Your job is to understand the statute by your own reading of it. You read the statute yourself. It's wordy but clear. It's not ambiguous, and determine what has to happen upon this respondent. The commissioner's attorney wants to focus the court's attention that TFRL applies, and that TFRL is all about the accident. Well, that's the small part of TFRL at the beginning, 104, 105. The whole rest of this very voluminous law is about the suspendee and the supervision of parties under suspension. Atwood has nothing to do with accidents. I've never said that it did. And he repeatedly makes that statement that I'm arguing that somehow Atwood deals with people who have had an accident. It has nothing to do with them. This law is focused on the Department of Safety's suspension program and making sure that these high-risk users of the road are under government. They are under the stick for a length of time of the length of their suspension, and when that punishment, as it were, with grace, punishment and grace together, is over, that person is free. He is released to not have insurance. He's free to be a free market actor, and if he can afford it and is wealthy, then fine. But if he's poor and he can't afford it, like me, I live under the poverty line. I have to weigh what I can afford, and if I can't afford it, well, then I, my Honda Odyssey minivan, which is worth $400, is at risk if there's an accident. He's focusing on the accident rules, and not on the suspension architecture, which is where Atwood applies. Atwood applies to the latter part of the statute, suspension. It doesn't deal with the first part of the statute, which is the qualifying accident. Again, comments he makes about 139A, that the law applies to every vehicle. Well, it can't. It simply can't, because it says that, and the reason is the rules of construction. And I provided in, I believe, my reply brief, an appendix of a magnificent court case that summarizes all the rules of construction. The rule ejusdem generis is violated, where a general term in a statute cannot be construed to overthrow the specific terms over here. General statutes are controlled by the narrower provisions. He wants you to believe that, well, the general provision overthrows all the specific ones. And if you make that mistake, then you're also not reading the law in paramateria. All the parts cohere. All the parts make sense together. There is no disjointure, there's no decoherence, there's no deconstruction, as the commissioner wants the court to believe. I believe that the presentations given here are lawyerly gazoozling. Atwood applies only to suspendees. As for hearing authority, under 67-105A1, well, it may be fine to quote that, but again, that very statute, as I pointed out in writing, has two exceptions clauses at the very beginning. They have to mean something, and also express order for due process command in 103 and 104 have to mean something. They have to mean that if there's a problem or a dispute under this law, it's heard within the confines of the statutory structure. The infrastructure is there for due process, and I've been denied due process by being in a hearing trapped. My being there in no way is a balm or cure for a court without subject matter jurisdiction. That's the Dishman versus Memphis Community College case that I've cited. There's no authority, and it's void. So no matter how well I did or how badly I did, great points or stupid points, however I perform, compliance and participation does not grant subject matter jurisdiction. That is a foundational question that he has answered. He has answered by saying, well, the hearings are under the tax law. Well, I hope you don't believe that. Mr. Barker also talks about notice as being due process. Well, that's not. Notice does not constitute due process. The department has ministerial authority to suspend licenses without a hearing. Why not? Why do we not have hearings under Atwood? Because they're previous to it in safety. The ministerial functions of this program upon suspendees is you're suspended. That's it. There's no hearing. There's no right for hearing in the way the system is designed to operate. the commissioner wants the court to believe that the law decoheres, that the amendment to the law is somehow completely separate, thereby allowing the court to not notice the things that are out of order. Atwood, yes, quoting the lawmakers, does put teeth into TFRL, just like 139 put teeth into TFRL. But the teeth are applied upon those who are subject to correction by the Department of Safety. And I will leave you to consider his comments about the certification issue not being really relevant. It's highly relevant. Atwood is all about the certified motor vehicle liability policy, as it says in the purpose statement in 202. The purpose of this part is to develop and implement an efficient insurance verification program. Again, verifying that something already exists for any particular user that utilizes data transfer standards for transmitting full book of business, the guide under the IICMVA, to verify whether the financial responsibility requirements of this chapter, the whole chapter, Part 2 and Part 1 are not separated, have been met with a motor vehicle liability insurance policy. And the fact that the word insurance is thrown into that word doesn't mean that the type of insurance required and looked at by Atwood is not the same as defined in 102. The word insurance does not cause a break. The requirements of this chapter have been met with a motor vehicle liability insurance policy, close quote. So that is the purpose of the statute. I'm here defending the statute. I want the statute to run properly so that it doesn't cause harm to me and to other people. Do you have any other questions for me, sir?
Not right now.
Yes, sir.
Okay.
Thank you for your time, Your Honor.
Thank you, Mr. Tellis. Okay. All right. So I'll take it all under advisement. Quite a lot to go over. As you both well know, it's a voluminous record. There's voluminous filings. But what would help me in my review of everything would be if you would each provide me with what you believe the order should look like. In other words, provide what order you would want the court to issue. Okay. And I will help you with that. If you would please have several sections in there, which will probably be familiar to you. Put in the, first of all, identify the parties, okay? Identify the nature, manner, and kind of proceeding before the court. Identify the operative pleadings before the court. Go through the relevant procedural history. Identify the appropriate standard of review. Provide a detailed analysis of the law as it applies in this particular kind of case, and then provide specific conclusions and rulings as the ruling, I guess, as to what you want to see happen, both sides. I appreciate the fact that that's going to take some time. Would a due date of September 15 be acceptable to Mr. Tullis and to Mr. Bark?
Yes, Your Honor.
Mr. Bark says yes.
Your Honor, is that something we would email submission or we follow with the court? Or?
Well, I guess both.
Okay.
If you could file it as well as email it to Ms. Cherish. Okay. Mr. Tullis, how about that date? Too ambitious?
No, sir, that's fine. Would you mind repeating your list again,
Yeah,
please?
sure. Absolutely.
So I can
Okay.
make better note.
Identify the parties. Identify the nature and kind or manner of the proceeding that is before the court. Identify the operative pleadings that's before the court. Provide the relevant procedural history. Identify the appropriate standard of review for this particular kind of proceeding. Set forth the legal analysis or analysis of law, and then provide specific conclusions and rulings that you would want the court to issue. Okay?
Yes, sir. And what's the title of the document?
Order or proposed order. Okay, all right. About that date.
Yes, sir. That date's fine with me. September 15. Yes, sir.
Okay, then, that will be our date for the proposed order to be in, to be filed as well as emailed to Ms. Cherish. After which, we'll deem the case submitted. Okay? Okay, all right, okay. Anything else?
No, sir.
Okay, great, all right. Thank you both.
Thank you, Your Honor.
Thank you, sir. Appreciate it.